Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Massing. To my left is Judge Nyman. And together we are your panel on the first 4 of the 5 cases we are hearing today. If you're good at math, you'll realize that 1 case is off the list. We assume you're all familiar with the rules. There are 15 minutes per side, no opportunity for rebuttal. Since 15 minutes generally is not a great deal of time, we urge you to the extent possible to cut to the chase. Please keep in mind that we have read the briefs, we're familiar both with the facts and the arguments. So again, please cut to the chase. That having been said, if you feel you've said everything and there's still time on the clock, there's no shame in sitting down. As one of my former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. With that, we will call the first case of the morning, 2023 P393, Commonwealth versus Ivanenko. And if I mispronounced that, my apologies.
Make sure I don't start coughing on the water I just drank. Thank you. Good morning. Kara Shayat for Alexander Ivanenko. There were 2 live issues on appeal, the video issue and the instruction issue. I'm going to focus on the video issue, but I want to make an effort to reserve at least a couple minutes of my time to provide a couple of clarifying points on the instructional issue. So there are several facts I want to highlight that set the foundation for why, in this particular case, the presumption that jurors follow instructions can't be relied upon, and why the risk that they didn't follow the instructions in this case created a substantial risk that justice was not done. So the first kind of foundational fact is that the Commonwealth elected to present the video evidence in one particular form, at regular speed, through without a pause, and at regular magnification. And
Can I just question the premise of this,
Yeah.
which is, how is enlarging the video on a computer any different from using a magnifying glass?
So that was my third, I'll just jump to that. That was my third foundational fact. So in Silva, there was physical evidence, a still photograph, sort of, I think of it as an analog, I'm not sure I'm using that word right, being enlarged with a physical device of a magnifying glass, right? So the judge said, and the court said it wasn't an abuse of discretion, to find that that's no different than using prescription eyeglasses. But here we have digital evidence, a dynamic video being enlarged with a digital tool. And so the likelihood that that would introduce distortion rather than clarity, just in the way that you can pixelate a photo on your phone to the point where it's more like a Rorschach test rather than something that actually is illuminating. So that's part of the danger. And the other piece of that is that the tools that are on the player that I suspect that the court has already tried or will use, that the tools are incredibly user-friendly and very intuitive, and it's not just an enlargement tool that's visible on that player. There's the speed up, the slow down, the frame by frame, the moving back, the moving forth, and those are right next to the enlargement tool. So the possibility that there was more being done in that juror room other than an enlargement, even just in their sort of moving around which is the enlargement tool, might have found their way to that, assuming they did that. So that's why, that's the distinction between this and the facts of Silva. And so the Commonwealth made its choice that it was going to do, like I said, how it was going to present it. And the limits of that choice were actually revealed almost immediately after trial started. Page 104 is where the complaining witness, this woman who is undisputably injured, starts testifying. At 111, the prosecutor shows the first clip. to the complaining witness for the purpose of her identifying herself on the MBTA surveillance video. And her response to that is, it's really hard to see, it's so fast. And so the prosecutor actually has to show it to her twice for the purpose of her identifying herself. The second sort of foundational fact is that the judge ruled in this case that it would be improperly prejudicial to permit the jury, the now deliberating jury, to view the video in a form other than the way the prosecutor chose to present it.
So you're at volume 2, page 13, and the judge instructs there, he says, to the extent that videos can be expanded or not, please don't do that. I'm ordering you not to do that. Do not expand the video, just watch it in its current form. And your argument seems to be that in failing to poll the jury after they rendered their verdict or when they came back out, the judge created a substantial, that was error number one, and number two, it created a substantial risk of a miscarriage of justice. What's your authority for that? That failing to poll the jurors as to whether or not they followed explicit instructions is error.
So the closest analog for that is where the judge, comes to the judge's attention that the jury has been affected by, introduced to, exposed to some extraneous information.
Where is the evidence that the jury was exposed to it?
So,
not that it could be exposed, but that it was.
So this is all then about the risk, that my argument is that there was a real and substantial risk that the jury disregarded the instruction because they told us that they wanted to, because doing so would have been so easy, and three, because the video that they wanted to see and asked to see again and again and again and again and again, that fifth time enlarged, went to the only disputed factual and legal element in this case, whether when Ivanenko's hand made contact with this woman's neck, whether that was intentional or accidental. That was the whole case. And so it would have been, and the fact that they file out with that laptop, minutes later, after ending up having to recess overnight, they file back in with their verdict. I think that to presume under these circumstances that the jury complied with the instruction is really to turn sort of a blind eye to the frailties of the honor system, because it's all about the honor system. And
So
I was thinking,
I understand your argument, and so I'm going to go back to my question. What is your authority?
I don't have so
A legal authority, a case, a legal support of any kind that says failure to poll a jury as to whether or not it followed instructions can be error.
And, when I was, it's in my brief, I believe the cases, I think it's Fredette and those other cases around that say sort of when there is, now of course I'm talking about risk, the risk that they would have violated it. And I'm sorry that I can't do more than point you back to my brief where I talked about that. But I think, in thinking about this, I think one analogy is you trust your teenager, you're leaving him home alone for the weekend for the first time, and on one hypothetical, you just sit him down and say, remember the house rules, no parties.
It's almost as if you've met my daughter. So.
So the other is your teenager says, hey, you're going away this weekend, I want to throw a party. And sort of what you do, what level of suspicion you have at that point when they've alerted you to the fact that they want to do something that's forbidden, and whether you take other steps. And my argument is this starts to become that possibility that, in fact, the jury would disregard it, and I don't think I'm pulling it out of thin air, given the ease with which they could have, their expressed desire to, and the centrality of this particular moment in the video to what was presented at trial, what they had to decide, and how quick, how they decided it. Did you have a question? No. So I just want to make sure that, and just in terms of the instructions, and obviously, I argue that the judge, when he gave all of those prophylactic recess instructions, not driven by any query of the jury, but just sort of in that first teenager hypothetical, by the way, here are the House rules, and every time the 3 times that the jury filed back without any reason to suspect that anyone had wanted to look on their phone or post something to social media, just a brief, we can all see your eyes, did everyone comply? This time again, where the jury alerted the judge to their desire to do something that the judge said was prohibited, and I sort of jumped over something. It's my strong view that the judge's ruling that in this case it would have been an abuse of discretion to permit the jury to see it in some other form, that's like the law of the case. That ruling isn't up for grabs. The Commonwealth suggests that
No, but doesn't it go to prejudice?
Doesn't what go to prejudice?
Whether the judge had to make that ruling. I mean,
Well, I think yes, I mean, the fact that he made the ruling is so much a part of my argument, absolutely. And I may be misunderstanding what you're saying, Justice Milkey.
I am still personally struggling with what the prejudice would be in this case if you were correct that the jury, tempted by enlarging it, went and did it. I mean, the jury's perhaps most fundamental role is to get to the truth. The thumb drive, as I understand it, was an evidence. And it showed whatever it showed. And I hear what you're saying, that it's, in a sense, the law of the case once the judge ruled that they couldn't do it. But I'm having a hard time with your argument the judge couldn't have let them do it.
So if I could tease those things apart. So start with, that's the rule that the judge set. The prejudice from the risk that the jurors didn't comply is that when they were looking at the video in this altered version, there wasn't a legal advocate there watching it with them to make the arguments about why it was introducing distortion, why they couldn't rely on it, why it was changing it, or maybe even to make an argument about, well, if we manipulate it this way, it corroborates what Ivanenko says. There's no advocate. I mean, the prosecutor argued in her closing about why just run at regular speed and regular magnification had supported her theory. But there's nobody in the room arguing about what that enlarged or distorted, perhaps, we just don't know, or otherwise manipulated evidence, what inferences could be drawn. There's no, we can't assume that there was a juror back there saying, well, I'm a little bit worried about this. It was the fact that this would have happened in the sanctity and the privacy of the jury room without a legal advocate. So we've got the judge's ruling, and I do insist that that isn't up for grabs on appeal. The Commonwealth didn't object to the judge's ruling in that way.
Suppose you, instead of raising this in appeal, you filed a motion for new trial. And the motion for new trial says, Judge, I'm concerned that the jury was exposed to extraneous material. What you had ruled as a matter of law of the case was extraneous material, which would be an expanded view of something that was in evidence. And so the question is, and Judge, I want to have a voir dire of the jurors to see. I want the jurors to testify to see if they were exposed to this extraneous evidence. Would Judge Frank on motion for new trial be stuck with his ruling that okay, we have to take it for granted that this is extraneous evidence, and then so you're entitled to a motion for new trial then as a matter of law to see if the jurors did that or not?
I think it would be awfully odd for a trial judge to then say, well, now that you're asking me a different way, I'm going to change that ruling. I think that might create then a new appellate issue, because I think that properly could be challenged. And of course I didn't seek file a motion for new trial, and in a certain sort of ironic way, this really is all about risk. I mean, it's almost, as I was thinking about it, it's almost like that standard of review that's what I'm talking about, the risk that these things might have happened. There was no querying of the jury, no at least looking at their face to see how they responded. So
Can I just note
Yes.
that 2 minutes or
I
less?
just noticed that as well. I appreciate that. Sometimes I read that. So let me just, a couple of quick points on the instruction. Again, the Commonwealth picked its lane, said we're going intentional battery. I think it's at page 120, at 29. The judge inquired, are you interested in reckless battery? The Commonwealth says no. So they're held to that on appeal. And I think if there's any question about them being bound by that, I think it's Commonwealth v. Lee at 1981. If you were questioning that, I'd love to submit a 16L. If they had gone for a reckless battery instruction, I think everything about this appeal would have changed. But the problem wasn't in the intention, the instruction on intent, it was on accident. So he was only entitled to that instruction because of his own testimony in his behalf. But the rule is that you can sort of use an object, an instrumentality, an intentional way, and still be acquitted of an intentional battery if the contact is accidental. Ford and Moore, it's pretty easy to tease.
So what about the language of that, on the definition of accident, what permits that? I don't see it.
I'm sorry?
What about so the judge instructed on page 195, an accident is defined as the unexpected happening, that occurs without attention. It means a sudden, unexpected event that takes place without the defendant intending it. So it is something the government must prove. How is that? If he keeps saying they have to, how's that a problem? He keeps saying he has to intend it,
Because that doesn't alert the jury that there can be both an intentional act and an accidental touching. So he would have had to say, I tripped as I was going across the door and I threw my hand out. He said, I put up my hand, whether it was out of rudeness, sort of, hey lady, I'm walking here. He said he had a bum ankle. He threw out his hand. The question, intentionally. The question is whether it then accidentally or he intended to touch her. And that's the problem I have, that the instruction doesn't permit that. He would have had to say, I fell, I sort of threw out my hand to, stop my own fall. And that's the error with the instruction. I see my light's blinking.
I'm sorry, I have one question. The Commonwealth agrees that there's duplicative sentences here, is it enough to just vacate the AB sentence, or does it need to be remanded?
No, I think it's just enough to vacate the duplicative conviction.
Thank you.
Thank you very much. We will hear from the Commonwealth.
Good morning, Your Honor, and may it please the Court. Aaron Stoudinger, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. Beginning with the extraneous influence by theory of viewing the surveillance video, I think most importantly in this issue is that under that line of cases, there must be some evidence that the jury were in fact exposed to an extraneous matter. So if it's falling under this sort of theory of they enlarged the video and it was an extraneous matter, there must be some showing either at the trial level or here that the jury were exposed to that. And here, the defendant is trying to substitute a presumption that, of course, they enlarged it for the actual evidentiary showing that's required. I think the claim fails at that point.
How could they possibly have evidence of that?
A juror could come forward, reach out to defense counsel, say, hey, we were repeatedly told not to enlarge this video and someone did it. If there's some sort of suspicion, hey, I think that this was too tempting, of course they had to enlarge it. The defense counsel at the trial level can reach out to jurors and inquire. There are processes for finding out if there is this sort of suspicion that the enlargement occurred.
I was going to just ask you the same question that I asked Attorney Chayette, which is, so suppose the defendant did file that motion for new trial. Is it the law of the case that enlarging is extraneous?
No, I think it would go to the prong, when you do the extraneous influence analysis, it would go to the prong of whether the Commonwealth has otherwise satisfied its burden, that I think it's, that the case would otherwise have come out the same. Something to that effect, and I can find it, it's in my brief. But it would go to the fact that there could be no prejudice from ignoring an erroneous instruction. Here, he could revisit the fact that I instructed them not to enlarge the video, but this is similar to a magnifying glass. That instruction was likely incorrect. there could have been no prejudice, therefore the Commonwealth would still succeed on the second prong of the extraneous influence analysis, which is essentially whether the case would have come out the same way. And so I think they could revisit the ruling and find that there could be no prejudice to the defendant from the jury ignoring an instruction that the judge now, on the motion for new trial, admits was given an error.
Now, you've heard the argument that the pixelation-related issues make this different than a magnifying glass. How do you respond to that?
I don't think that's necessarily true. I think you're going to have some sort of image distortion with a magnifying glass, just as you're going to have with zooming in. I would say it's akin, and you see this in the case when the judge invites the jury to come forward when they're playing the video in the first instance. I think one of the jurors asked, "Okay, can I move closer?" And he permits that. The line of cases that prohibit digital media being manipulated, there's no manipulation here. There's no
editing.
There's no there's no editing. There's no like all the CSI shows where they enhance and all of a sudden the image becomes perfectly clear. This is a case where they would just be zooming in. It's the same as a magnifying glass. It wouldn't manipulate the digital evidence in any degree. And so that, I think, even though there may be some distortion when you zoom in and zoom in and zoom in, the media is being presented in its original form. No manipulation has occurred, and therefore the zooming in is the same as a magnifying glass. And then
On the intent instruction, defense counsel cites the Ford and Moore cases to support her arguments. How would you distinguish those cases? Are they distinguishable?
These cases are very distinguishable. I think the defendant's argument is largely the same argument that was made in Ford and Moore, with the difficulty that the instruction had been specifically amended to or changed to address the issues in Ford and Moore. In Ford and Moore, the language was to the effect of that it was the intentional result of an accidental act, or maybe I have that backwards, the accidental result of an intentional act. And so it created the notion that where the defendant did an act intentionally, the results that followed were their intentional act, even though they might be accidental. It's somewhat of the Rube Goldberg machine, where you set in motion the series of events that eventually hit the victim, and the Moore and Ford instruction permitted that to be an intentional touching.
In Ford and or Moore, did the judge instruct the jurors in either of those cases that they must find that the defendant intended to touch the victim? Do we know if that was part of the instruction in either case?
I think in Ford and Moore, he instructed that the defendant need only intentionally do the act that results in the touching.
Okay.
And here I would say that's exactly the point, is that taking the instructions in total, the instructions on the intentional touching for AB 60 plus and the AB DW, when you take the instructions as a whole, it eliminates any danger that the accident instruction could have created, because he specifically instructs the jury that the defendant must have intentionally touched the victim, and that the touching was not, he deliberately intended the touching to occur, and that the touching was not merely accidental or negligent. And so the instructions leave no doubt that it is the defendant's touching of the victim that must be intentional and cannot be an accident. And so I think taken as a whole, the jury instructions leave no doubt to satisfy the elements of an assault and battery. In any event, I would say that there could be no substantial risk of a miscarriage of justice here when there's no version of events that could kind of feed into that purported error in the instruction. This is an event where an incident where the defendant reaches out and strikes the victim. The victim testifies that he reaches out and strikes her. The witness testifies that he reaches out and strikes her. The video shows that he reaches out and strikes her. His testimony is, yes, I put my hands up and hit her, but it was an accident. There was no version of events where some intermediate act occurred. The jury were presented with a touching. His version of events was, I saw her coming towards me and I reached my hands out. The victim's version of events was that it was intentionally reached out. There's no sort of intermediate act that the purported error in the accident instruction could have fed into. It was strictly a single touching, and it was whether the jury believed his version of events or the victim's. They were permitted to ignore his testimony. And if there are no further questions.
Thank you very much.
Thank you.
The case is submitted. Our second case of the morning is Commonwealth versus Lyman, 2023 P479.
Good morning, Your Honors. May it please the Court. Andrew Power on behalf of Defendant Keith Lyman. Now I'll begin with the first issue, the issue regarding the self-defense instruction that was not given and not objected to. The question of whether an officer used unnecessary force to subdue a defendant is a question of fact for the jury on proper instruction by the judge. Now that instruction is given on the basis of evidence viewed in light most favorable to the defendant. All reasonable inferences are resolved in favor of the defendant, and the defendant's statements in the record are presumed to be true. So the threshold for a self-defense instruction is low. Now in this case, the evidence showed that my client had a reasonable concern for his safety based on the trooper's unnecessary intrusion into his car. My client did everything he could to avoid contact with the trooper, trying to drive away to a safer location, a nearby police station. And finally, the force used by my client against the trooper was minimal. It was only what was necessary to get the trooper's arm out of his car so he could drive to a place that objectively was safer than the dark side of a road at 11:20 p.m. Now that led to a substantial risk of miscarriage of justice because my client did not have the benefit of a self-defense instruction.
So is it a benefit? So there's a discussion of whether what the judge, discussion on the record of whether the judge is going to give a self-defense instruction. And the judge says, and defense counsel has this different theory about how he wants to approach it. And then the judge says, I'm not going to give self-defense. And defense counsel doesn't say, well, I really need you to. And could that have been a strategic decision? Because if the judge gives self-defense, then defense counsel's got to go through, the reasonableness of the force, and did the defendant try to retreat, stuff like that, as opposed to just the argument that he made was that my client acted totally reasonably. He sort of made self-defense without the baggage of a self-defense instruction. So could there have been a strategic reason for not asking for it?
It couldn't have been strategic because I do believe he was making the self-defense argument. He was making a justification argument, and there was no other justification. It wasn't accident. It wasn't consent. There were no other defenses, really. It was self-defense without using the term self-defense.
What about the reason? What about taking steps to avoid combat?
That's part of the self-defense calculus.
The testimony, I think, right, the officer reaches his hand. He doesn't touch your client. He's going for the door.
Right. That's understood by my client. He's trying to forcibly exit my client from the car. So he's opening, the door is locked. My client's trying to drive to the police station, puts the car in gear, and the officer sticks his arm in to unlock the door, presumably to rip my client out of the car, either to do that or to do what he did later, which was to try and shoot him with a taser.
Right. But so defense counsel argues to the jury, he was reasonably trying to swat him away.
Exactly.
And why is and you don't couldn't that have been like he didn't want the jurors to have to think about it a different way? Like he just the simple way he was doing it?
I think you get a clue what he's doing when he says to the judge, what I want. I think he was a little confused as to how exactly to frame the instruction, because when they're talking about the consent instruction, he says, well, what I want is almost like self-defense. We're kind of like self-defense.
No, but couldn't that be interpreted as, in the same vein, he saw problems with arguing self-defense? This is not a case where he didn't think of self-defense. There's a discussion on the record about the issue.
So yes, I think he thought of self-defense, but I don't think he made a strategic decision not to argue self-defense because he was in fact arguing it. And the problem is, in the end, he made the self-defense argument without getting the benefit of the self-defense instruction. Now, the self-defense instruction has a really big benefit, which is that if you find that the Commonwealth has not established beyond a reasonable doubt that this was not self-defense, you must acquit. So he doesn't get, the jury is not instructed on that. And the jury is interested in that argument. We can see from the jury's questions that they're wondering, you know, they're focused on the fact that he felt unsafe. He wanted to move to a safer location. They're wondering if it would have been proper for the police officer to direct him to that safer location. So they were picking up on that argument, but there wasn't a way to get to an acquittal on that basis because the jury weren't instructed accordingly. And that's where the substantial risk comes in, because the Commonwealth had the burden under self-defense to establish that it was not self-defense beyond a reasonable doubt. And that burden was not imposed on the Commonwealth by the judge in this case. So the jury did not consider that as they should have. So I think trial counsel was definitely arguing some form of self-defense. He was thinking self-defense, but he did not make a strategic decision to avoid that benefit, to eschew that benefit, basically, of making the Commonwealth prove beyond a reasonable doubt that it was not self-defense.
Would you agree that the defense here was equally akin to a necessity defense?
I don't see the necessity defense because it's more self-defense. I don't see how it's a necessity defense because he didn't need to touch the arm for a greater good. He wasn't sort of forced into that. He was threatened. The elements of self-defense play very, very nicely with this fact pattern. He felt that he was unsafe. He felt that the officer was threatening him. Whether or not the officer used unnecessary force, that's a jury question, but I think there was enough there at least to get it to the jury. Right. And it's clear he was trying to avoid the contact. I mean, he was trying to drive away safely, not screeching his tires, but moving very slowly away from the officer until the officer could follow him.
I was just looking at the instructions on necessity, and the Commonwealth must prove one of three things beyond a reasonable doubt to show that there is no necessity. First, the defendant was not faced with a clear and imminent danger, but rather one debatable or speculative. Two, the defendant did not reasonably expect his or her actions would be effective in reducing or eliminating the danger. And third, the defendant had a reasonable legal alternative. Almost strikes me that it's similar, but almost more accurate here based on the facts that were presented.
It seems
speculative. You seem to disagree, but...
Yeah, I think it's speculative, and I think it's also telling that nobody raised the necessity defense. Nobody mentioned necessity in the course of the jury instructions, while trial counsel did actually, you know, say like self-defense. He was kind of stumbling towards the self-defense instruction, even though he didn't get there and he didn't object to the instructions in the end. So, and I think if you look at the case law also, self-defense fits very neatly as a defense to ABPO. You don't see necessity coming up as much as a defense to ABPO. The major cases, Graham, Urquhart, Eberly, they're talking about self-defense.
Have we ever seen a self-defense instruction given in a context like this where an officer who's in uniform in a marked cruiser stops someone and the self-defense instruction is basically, I'm entitled to drive off and he can't do anything to stop me about it?
Well, it's not exactly I'm entitled to drive off. It is...
I need to drive off. I need to get away from him. So, I mean, have we ever seen a self-defense instruction given in a context like this? Do you have any legal authority for that?
I think when you look at the major cases, the actions of the officers are much worse. You have people getting their teeth knocked out, you know, elbows dislocated. It's far worse. And also what the ABPO acts are also usually worse than what you see in this case. So this is really a small-scale case, I would argue. I don't dispute that. But I think the same rules apply. So we're not seeing, at least published cases, devoted to small-scale incidents like this. But I think the Graham factors, the three factors that I mentioned, apply equally to this case as they do to the, harsher cases involving conduct that's more clearly violent and personal.
If this were a civil case, I personally would be inclined to say you have a very strong argument on the equities, but not so much on the law in terms of whether or not the conduct here meets the elements of the crimes charged. The judge appears to have taken into account again, what I might refer to as the equities in the sentencing, and did not order any jail time, even though nominally the offenses here are pretty darn serious. How do you respond to that?
I agree. I think that the fact that the judge imposed that sentence was a recognition that the evidence of self-defense was cognizable, at least was there, and this conviction might be mitigated, perhaps, by a lighter sentence. So the judge may be saying, kind of like a ref who misses the call and then calls a foul later on something that may not be so clear. So I think the judge is acknowledging, in a way, that sentencing may be an acknowledgement that a self-defense instruction may have been appropriate in this situation, and if it had gone to the jury, there may have been a different result.
Now, some of the cases you cite, or the incidents, like the Rochester matter, arose in a sort of racially charged environment. You do not appear to be making any race-based arguments here, which leads me to assume that you don't have them to be able to make. Is that a fair assumption?
Yeah, basically I'm just going on the record, so there's no, trial counsel didn't make a race-based argument. I looked at it, there's no motion for new trial based on race. But I think it was a race-based climate in 2021 of police misconduct, especially, with George Floyd and then Daniel Prude in Rochester. And what those go to is familiarity, a greater focus on police misconduct, and these police encounters at the roadside that can really get out of control. And I think that went to my client's legitimate fear and legitimate concern that something strange was going on. There's a police station right down the road, and he'd feel much more comfortable giving himself up and getting out of the car at the police station than he would at this dark roadside in the middle of nowhere. And so I think we see on the video that, and that's where the video comes in, that's trial evidence, that he was thinking about this stuff. Not only was he aware of sort of generally of police misconduct on a national basis, but he was also familiar with this specific case of somebody who was basically suffocated by police. They put a bag over his head and pressed him until he couldn't breathe anymore. Again, without going into the merits of that situation, it shows that my client knew about it, and it informed his fear of the roadside encounter at that time. So he legitimately felt unsafe at that time, and the conduct of the officer went to that, made it worse.
Can I ask your second argument for the sort of a justification instruction? That's limited to failure to stop cases?
Yeah, failure to stop, and I think it also plays back into the ABPO charge as well, because that was also linked.
Well, okay, so now you're giving me now you're a less clear answer.
Okay, so the way I presented in the brief, it's failure to stop.
Okay.
And basically, there should be a reasonableness requirement on a failure to stop instruction. So it's not, because people recognize that there are some places where you're pulled over that may seem unsafe, may objectively seem unsafe. So should the jury be instructed on a reasonability that if the person feels it's unsafe, if it's objectively unsafe, is it okay, is it justifiable for the person to drive a little farther until they can find a place that's objectively safer to stop?
If we were to agree with you on that, we'd be making new law, right?
I believe so, yes. I don't believe that's...
I mean, so so how do we do that on a substantial risk case? Like, create a substantial risk of miscarriage of justice for not giving an instruction that's not required, or asked, or even asked?
How do you do it?
It would have been better, it would be better if it had been raised at trial so that it could actually have been developed, I suppose.
Absolutely. It would be better if we had an objection and a different standard. But even under the substantial risk, if it's appropriate, I believe you can rule on it and impose it, at least just reasonableness. And I see my time is up.
At the risk of causing ire to my colleagues, based on clouding his taxonomy, these arguments, I take it, are all related. Your argument on point 2 is related to your self-defense, is related to the issue of necessity. It's all kind of one.
Correct. It's one incident, and they all kind of come together, yes.
So, thank you very much.
Thank
We
you, Your
will
Honor.
hear from the Commonwealth.
Give a low standard for ire.
Good morning, Your Honors. May it please the Court, Cynthia Von Flatern, Assistant District Attorney, Northwestern District for the Commonwealth. The Commonwealth would submit that the self-defense instruction was not appropriate and the judge correctly held, where the case law is very clear that first, when you're talking about assault and battery on a police officer who is known to be a police officer by the defendant, he's wearing a uniform, he has his cruiser, he's identified himself as a state trooper, that the standard is that there would have to be excessive or unnecessary force. This is not just a case of self-defense or just saying that you disagree with the basis of the stop.
I understand your arguments on the law, and there's frankly a lot of force to them. This trooper, at least from my perspective, I'm not going to try to speak for the panel at the moment, was off on a frolic and detour in terms of his conduct. He did not have a basis for prolonging the stop. Is there nothing that can be done, or is this just a question of sentencing?
Well, I think, and of course, we're reading, this all occurred in 2021, which is a difficult climate at that time, and we have the Chown case and the 90 chapters 3.5 factors when somebody has an out-of-state license, when their Massachusetts license is expired, and so the trooper is dealing with that. But the testimony is that it was a very quick inquiry. It was not a particularly long stop, and I understand that the defendant had a New York license, and the Commonwealth doesn't dispute that license was active. And
the trooper confirmed he had a registration that was active.
Yes, not with him, but he had an active registration. So yes, under Chown, the stop should not have been delayed. So it was not delayed very much, but and there were still some factors that were not clear to the trooper, because the trooper was very clear that right from the get-go, the defendant was in a bad mood, agitated, abrasive, short with the trooper. And it started when he didn't understand why the trooper said the inspection sticker had expired, because he wouldn't have been able to see the inspection sticker in the dark. Well, of course, he saw it on the computer. So the defendant was never giving the trooper clear answers, and so he was just trying to get to the facts.
But the trooper was actively looking to pull someone over. Will you at least give us that?
Well, I think once he saw that the inspection sticker was expired.
Once he ran the plates because he had nothing better to do.
Well, and the license was expired, so he made the determination to
Is there a motion
make
to
the
suppress
stop.
filed in this case?
Not that I'm aware, no, because we have looked at the docket, and I don't
Motion to
see a
suppress
motion
the
to
exit order,
suppress.
anything along those lines?
I don't believe so, Your Honor.
And there are remedies for the concerns that the court is expressing, correct?
Well, there was a charge of operation without a license which was dismissed. And so I think the case law would be, and there is an abundance of case law, including the cases that are really on point here, like Commonwealth versus Urkel, where if there could be a suppression issue, but that doesn't excuse an assault and battery on the police officer. So the suppression issue is really separate. And I understand the court has concerns about the equities, but in terms of assault and battery on a police officer, the case law, I think, is quite clear that we look at the basis of the stop and whether it was improper or whether it was extended too long or whatever. That's really another issue. And really, this is an intervening factor when you talk about somebody actually assaulting the police officer. And again, and this was a very quick interaction that became longer after the defendant drove away. I don't know how it would have ended if he didn't do that. But at the time that the officer was looking into the license, he did not have that much information.
If the defendant, as the driver, had a reason to believe there was no basis for the stop, that, at that point he was not aware that the information about the sticker was gleaned from the computer and not from the absence of a sticker on the front of the car in the dark, and there's no basis to order him out of the car, and the trooper, starts to reach into the car, and I believe there's testimony that he was going to pull him out of the car. Wouldn't that give a reasonable fear to the driver that something bad was going to happen when during that period, it seems like every week there's something on the news about a motorist getting stopped by police and then seriously injured or killed as a result?
Well, Your Honor, I don't think that we have testimony that he was going to pull the defendant out of the car. And the testimony is a little bit vague, but he does say that he has made a determination that he wants to talk to the defendant further and will ask him to get out of the car. But he only reaches into the car when the defendant starts to put the car in drive, which is a very unsafe thing to be doing on the side of the road. There's no testimony that he's going to pull him out. There's no testimony that he asked him to get out of the car. So I think asking somebody to exit, which happens all of the time, it is a stop. It is you're in temporary custody, but that's different from pulling a defendant out of a car. And I would definitely dispute a set of facts where he's going to pull him out of the car. That's not the facts here, even in the light most favorable to the defendant. He does not reach into the car until the defendant has placed the vehicle in drive. And then, that's a very dangerous situation for the trooper to be in. And I would also dispute this. After he is assaulted by the defendant, in the testimony, he's punching on his arm and his hand and then rakes his hand. And again, it's not, he doesn't kick him and he doesn't beat the trooper, but he does clearly assault him. Then he steps away and he does pull his taser, but he did not use the taser. He warns the defendant, but he does not use the taser. And there's no evidence to suggest that he didn't use it because something else happened or whatever. All he did was reach for his taser and warn the defendant, but he does not use his taser. And then the defendant drives away. So, I think the Commonwealth's view of this is that the issue about the the correctness of the stop, and I think there's no issue that the stop was correct, but about how long it took and about what the trooper's belief was about the defendant's residency was a legal issue, and that the defendant in this case should not have reasonably have taken matters into his own hands by striking the trooper and then driving away as he did with the trooper at the side of the road. I think that does lead into the second issue, and this case law from out of state, which is not the law in this case. And again, we had no request for that instruction. And as your honors had indicated, this issue is the standard of review is substantial risk of miscarriage of justice. There is none here, and there would be no instruction warranted in this particular case. In that Cohen...
My understanding from your brief, and I haven't looked at this case yet, is that the instruction requested on appeal under Indiana authority is not even Indiana authority.
That's correct, Your Honor. That was an intermediate court that made that suggestion. I think it was...
Only an intermediate court?
Yes, and that would be fine, but then...
To be clear, that court said this instruction should be given, and then the Indiana Supreme Court came in and said, no, it should not.
Yes, Your Honor. And in that case, it was not even error in that case, because the issue was whether there was a mistake of fact or mistake of law. And I think the court has already had an interesting discussion about reasonableness with my brother, and I think in the facts of this case, that standard is not met. One of the concerns, and I think the case raises some interesting issues. So one of the concerns is when you, if a person has a concern that they are being approached by somebody who isn't even a police officer, and that's not a concern here. And that's identified in a TRF by the Massachusetts State Police. Says if it's a low profile or an unmarked car and you have concerns, then a person could drive to a more populated area. This cruiser was well marked, and the trooper was certainly identified. So there was no concern there, and there would have been no reasonable concern with the safety of the trooper himself. This wasn't a 10-lane highway or anything like that. The location of the stop was very safe. The defendant did tell the trooper that he wanted to go to a more populated place, and there is no evidence about whether the location of the stop was well lit or not. So he did say that he wanted to go to a more populated space. But the Commonwealth would submit, in the facts of this case, the defendant stopped, and he only determined that he wanted to go, that he wanted to leave when he was frustrated with the trooper, and that started with that question about the inspection sticker. And again, whether it's clear under Chown that that line of questioning should not have continued, but still the defendant's remedy was not to drive off like that. If there are no further questions, the Commonwealth would submit.
Thank you. Our next case is 2023 P367, 133 Brimble LLC versus 143 Brimble Avenue LLC. Counsel.
Good morning. May it please the court, William Sheehan for the plaintiff appellant, 133 Brimble LLC, also appearing for CEA Brimble LLC, which seeks to be substituted as the party in interest in this case. There was a sale after all the matters were briefed in October of 2023, so that now the party who has something at stake is CEA Brimble LLC, and I would ask the court in its discretion to allow that motion. The issue in this case, of course, is whether or not there is standing to take the appeal, which was taken by the plaintiff appellant. And that, in turn, is going to depend upon whether or not we were able to establish that we have a problem, a peculiar problem, unlike the rest of the city of Beverly, with respect to the inadequacy of the parking at 143 Brimble and its effect. The evidence that the parking lot is, that the parking was inadequate at 143 Brimble is actually provided by the zoning ordinance itself. The zoning ordinance says that whereas here, the property is going to be used for 4 uses, so-called mixed use under the ordinance, that requires that the applicant for relief satisfy the parking requirements for each of the uses. And in this case, that's 72 parking spaces. But the parking lot that was provided to the Zoning Board of Appeals had only 49 compliant spaces. And there's no question of fact on those 2 issues.
But as a matter of fact, the judge found, and frankly it appears to be undisputed, tell me if I'm wrong, that there would be 74 painted spaces available. So your argument is, as a matter of law, you can't look at 49 of those because they're too close to the lot line, correct?
You can't look at 25 of those, so you
Between
can only look,
25.
so you can only look at 49 of them.
Yeah.
That's exactly right.
Standing is a question of fact, correct?
Well, standing is a question of fact, but there are legal issues involved here as to that standing, and the interplay, if you will, of the legal issue and factual issues with regards to adequacy of parking, and it really is the major question, in my view, the legal question in this case, is what is the standard for standing when you have a parking situation like this?
Now,
Is it
as I understand the configuration of the site, when they redrew the parking lines, they moved the parking back away from the boundary of their lot and your client's lot, that to the extent there are, in your view, non-compliant spaces, they are up against the Commonwealth right-of-way for 128. Is that accurate?
There are parking spaces that are non-compliant throughout the parking lot. There are a number of them that are too close to the property line with respect to the Commonwealth of Massachusetts Route 128. There are also parking spaces that are too close within the front yard. There are also spaces that are at the back left, if you will, of the building as you look at it.
Why doesn't your client have the exact same problem? That the, unlike the defendants, your clients, I expect, are still parking against the boundary because that's where their spaces are. Is that correct reading of the record?
My client does have parking spaces that are close to, within 15 feet of the boundary line, but there was no suggestion made and any argument made by any of the defendants that that created a problem, that it interfered with the standing. The standing in my client's situation is that it is going to suffer the consequence of overflow parking if, as the ordinance says, the parking is inadequate, and if the standard as to adequacy is set forth in the ordinance, which I would suggest it should be for the reasons I've stated in my brief. As to whether or not that overflow parking is going to come on to 133 Brimble Avenue, the answer to that question is yes, and that satisfies the two, both the quantitative test and the qualitative test regarding, under the Butler case, to show that the specific facts. Mr. Santon, who was the owner of 133 Brimble for many, many years, observed 2 to 3 times a year, not often.
This is before the Jersey barrier, correct?
I'm sorry?
This is before the Jersey barrier was put up.
Yes, it is.
Doesn't that make all the difference in the world where now if there's not available parking in the triangular lot, I get the numbers mixed up, if there's not available parking at the rug store, you're saying the people are going to figure that out or drive in and drive out, drive down Brimble Ave 80 feet, go into what I suspect is fairly obviously someone else's property, park there, and then climb over the Jersey barrier.
You don't even have to climb over the Jersey barrier, Judge. All you have to do is go back out onto the sidewalk and walk back over to 143. And the answer to that question is yes, the Jersey barrier isn't going to prevent that. It's designed to inhibit it, but it's not going to prevent it because anyone who goes to 143 and doesn't have a parking space there, there's no other place to go other than the property at 133. You can't park on 128, you can't park on Brimble Avenue. It's the only place in town, if you will, that is going to be available. There's no parking garage, there's no public
And you were just starting to say, the evidence of that is your client's sort of anecdotal observation that 2 to 3 times a year, what?
So my client, generally speaking, when it was the Veterans Post, had a good relationship with the Post because most of the activities of the Post were in the evening. My client's tenants are there during the day. However, there were times when the Veterans Post would have events during the day.
Maybe a wedding, something?
Maybe a wedding, oftentimes actually more like a funeral or reception. And what happened on those occasions? It happened regularly. It didn't happen often because there weren't that many functions. But when it happened regularly, folks who couldn't find a parking space at 143 would come to and park in the parking lot of 133. And specific facts are required to prove standing. Those are the specific facts. Now, the suggestion is being made by the defendants that Mr. Santon is speculating that there's going to be overflow parking because of the rug store. What Mr. Santon is saying, he's satisfying the second of the 2 elements that we have to satisfy. Number 1, that the parking is inadequate, and number 2, that because it's inadequate, where will that overflow parking go? Mr. Santon has the first-hand knowledge of that and articulated specific facts so as to satisfy the qualitative and quantitative tests.
And can we go back to the assumption that the parking is going to be inadequate?
Yes.
Other side had an expert who the judge credited.
Correct.
The judge made a specific finding. There's only going to be, I think it was 29 spaces per day. And that was a factual finding. Don't you have to, putting aside your legal argument that they shouldn't be able to look at the 25 non-compliant spaces, don't you have to show that that finding is clearly erroneous?
Yes, and it is clearly erroneous, and I've argued this in my brief, but specifically, we had the so-called expert testified that she did 3 forms of analysis with regards to the sufficiency of parking. The first was the so-called ITE manual test. The IT manual test, she admitted on cross-examination, resulted in an absurdly low, that was her phrase, not mine.
No, she didn't choose it, correct?
An absurdly low result. And it was that because we have 31 employees presently at Landry and Akari. And the brief details what's likely to happen with respect to numbers of employees in the event, which is the reason that Landry and Akari has spent $4 million to acquire the site and develop it, there's an increase in customers. But to go back, Judge, that's what, so she acknowledged that the ITE test was a failure. With respect to, she then said, I also looked at zoning. We've just talked about the zoning, requiring 72 spaces. She then said, I relied on the existing customer count, existing employee situation of Landry and Akari, now in Salem. But everything is doubling, Judge, and the retail space is doubling. The principal, Julia Akari Cook, of Landry and Akari, acknowledged she had, her term, no idea what was going to happen as far as an increase in customers. So the suggestion that somehow there was factual evidence that would warrant moving away from the standard that we urge, which is look at the zoning and what's required.
But a lot of the flavor of your brief is the expert essentially, in lay terms, pulled a fast one. You don't use that phrase, but that's kind of the flavor that, they're playing with numbers to try to reduce the amount of parking. Wouldn't it be idiotic for someone trying to put a rug store there to put it in a site where there's inadequate parking and no available public parking? Don't they have an incentive to get the on-site parking issue correct?
They would have an incentive to do so, and they could have tried to do so by way of seeking a variance, which is what they really needed here, Your Honor. The reason that the standard is the zoning ordinance is that unlike in Marashlian, which is a case that obviously we lean on heavily, unlike in Marashlian, let me put it this way, in Marashlian, the hotel owner who said the zoning requires 900-plus spaces, and I only have 150 or so, but that's okay because that's all I need. That owner properly got relief from the zoning ordinance, and the relief was you've got a variance from the number of spaces. That did not happen here, and that's central to the application of the standard, and it's also central to the error that was made.
How does that go to standing? Because standing is the only issue we have in front of us.
Because we're going back to parking. And parking, in order to contend that we have satisfactory parking, Mr. Sheehan and his client are wrong saying that the parking lot is inadequately sized. The only way they can get that relief is by way of a variance. There's also a provision if you're not talking about the number of spaces, but rather the different elements of parking spaces, then that power is in the planning board by way of a special permit. But there was no power here, Judge.
That's assuming that your client has made the requisite showing of qualitative and quantitative evidence that parking is inadequate, correct?
No question.
And let me just, along those lines, am I correct that the crux of your evidence is your client's testimony at Record Appendix Volume 4, page 124, that's 376 and 377 of Santon's deposition?
Yeah, it's the testimony of Mr. Santon as to what he has observed. That's exactly
in particular
right.
at those 2 pages, or am I missing more?
That sounds right, Judge. I honestly don't know.
Okay.
Judge, I just want to spend the last minute and a half that I have talking about the Schlein case because there's a suggestion being made that my argument, which is premised on Section 59 and its application, is in error under Schlein. Schlein, I know Justice Neiman knows that in Schlein, what happened was there was an owner who had a 20-room lodging house, converted it to 6 residential condos. Argument was made that the parking was insufficient under Section 59, and that panel said does not apply because we're dealing with Section 82C. This is not a Section 82C case. It's not an 82C section case because of the arguments, because of what I've said in my brief, but in particular, there was no evidence that the predicate of an 82C substitution of use, that is, there's an existing non-conforming use that's lawful, there was no evidence of that. In addition, Schlein should not be argued by the defendants now because they did not raise that issue below, and it's an entirely different theory to say that Section 59 does not apply when everyone, including their experts and including the judge, all commented on and looked at whether or not Section 59's requirement of 72 spaces was satisfied.
But in any event, Schlein, well-written as it may be, is not precedent in any event.
Thank you very much.
No, one question, just a hypothetical, and I realize it's not the facts here, but let's assume that your clients had a gate at their parking lot that prevented any unauthorized entry into that parking lot. Wouldn't, under those circumstances, the question of whether or not there was adequate on-site parking lot at the rug store be completely beside the point for standing purposes.
It would not be beside the point. However, the second element of what we have to prove, that is inadequacy of parking, and it's going to come our way, that would interfere with the second argument about that it would come our way. So that's how I would answer that hypothetical question, Judge.
Thank you very much. We'll hear from the other parties.
Good morning, Your Honors. May it please the Court, Donald Pinto for the defendant, 143 Brimble Avenue, LLC. As Your Honors noted, this is not a case like some that come before the Court on standing where there was a summary judgment decision. We had a full trial dedicated solely to the standing question, so the appellant has to show that the land court's decision was clearly erroneous. And given the complete absence of any relevant evidence presented at trial relevant to the sole issue, which is the future rug business, not the past post
What do you do with the cases, and they're cited by the plaintiff, that seem to suggest that in the resolution of the standing issue, you're really not supposed to focus the trial on that and, resolve the merits of whether or not there is going to be a sufficient impact or not. If it's sort of in the ballpark, that's enough. If you have a strong enough claim to standing, again, that's the question, not, oh, let's have a trial on impacts. Some of those suggestions in the cases lie in some tension with the Kenner case. Just for the record, I was the appeals court judge who was flipped on the Kenner case, so I'm quite familiar with the facts and arguments there. What do you make of this tension in the case law? Do you think Kenner overrules that line of cases, or we don't need to reach it because the numbers here are so far off it's beside the point?
Well, I think the latter first, the numbers here are so far off, it's beside the point. But, the case law has evolved over the years, and it's certainly true that a plaintiff does not have to prove that he will inevitably be harmed by the zoning relief that's granted. But he does have to prove that it's reasonably likely he's going to be harmed, and he has to present, and this is the Butler test, evidence that meets a test of quantitative and qualitative sufficiency, but it is about likelihood. Here, the land court could not possibly have found likelihood of harm based on the evidence that the plaintiff presented, because the plaintiff came to trial knowing there was going to be a traffic expert on our side and chose to come to trial with simply the client's anecdotes, and they're irrelevant anecdotes. They're anecdotes about the past post-event space use, had nothing to do with the future.
Wasn't there some testimony of a direct observation of somebody climbing over the Jersey barrier to get to the post?
There was, Your Honor, a completely unsubstantiated anecdote about one occasion, and Mr. Santon had owned the property for something like 15 or 20 years. That one time after he put up the Jersey barrier, he saw someone climb over the Jersey barrier. But that, again, has to do with the post use, which is an event space and social club. A retail high-end rug store is a completely different use, very low traffic generating use. If there are 3 or 4 people in the store at one time, it's very busy at a high-end rug store. In terms of the employee count, the testimony at trial was there are about 29 employees, but not all of them drive cars. Some take public transportation to work. Not all of them are there at the same time. They have varying shifts. Some come in the morning, leave at noon, et cetera. Some come just in the morning, pick up rugs, and they're gone all day in a van delivering rugs to customers' homes. So
Can I ask you, was it explored at trial whether the employees are going to be able to access it by public transportation in the new location?
There was, Your Honor. Our traffic engineer testified to the proximity of public transportation to the site, so that was covered. But the upshot of the expert's testimony was there's going to be more than double the amount of parking spaces needed at the times of peak demand. peak demand will be 29 spaces occupied. There's going to be 74 spaces. As Justice Milkey pointed out, the 29 spaces that are within 15 feet of the property boundaries are not imaginary spaces. They're full-size, standard parking spaces, and it's well within the ZBA's authority in a special permit context to say, we're going to allow you to use those spaces because you're improving the situation. You're reducing the nonconformity of the parking lot.
Am I correct in reading the record that in the reconfiguration of the parking lot, spaces were moved away from the boundary between these two parcels?
Well, essentially, Your Honor, some of the spaces before the Jersey barrier was put up actually straddled the boundary. So it was a very irregular situation. Once the Jersey barrier went up, that made a clear demarcation between the two properties, and all of the new spaces are entirely on the 143 side of the line. Some of them are within 15 feet of the boundary, and the ZBA thought that was great because it's reducing...
Of the boundary between the parcels?
Yeah, there's some along that boundary and some along the rear, I'd call it the rear boundary, that backs up to 128. But the net result is more conforming parking spaces and fewer non-conforming parking spaces.
I realized it has not been argued and therefore presumably is not before us, but to the extent that there are still non-conforming parking spaces next to the boundary between these two parcels, couldn't an argument be made that, the whole point of the setback requirement is to keep parking away from the boundary line, and the plaintiff is injured by the fact that there's going to be parking next to the boundary?
Well, as Your Honor pointed out, and as my brother conceded, immediately on the other side of the boundary, there are also parking spaces that are used by the 133 property, and that's always been the case. So there's always been nonconformity on both sides. But again, in the context of an application for a special permit under Section 300-82C of the zoning ordinance, the Zoning Board of Appeals has ample discretion and authority to allow an improvement in the nonconformity situation.
In your view, do we need to go there? Or is it...
I don't think we need to get anywhere near there, given the case law. I mean, what the plaintiff is doing is what the SJC in Murchison said you can't do, which is conflate violations, alleged violations of a zoning ordinance with the harm that's required to show standing. And they were clear in that. They said, and this is a quote, creation of a protected interest under a zoning ordinance or bylaw cannot be conflated with the additional individualized requirements that establish standing. So the trial was all about harm to the plaintiff from the proposed rug business. The plaintiff presented no evidence whatsoever on that. They chose to try to make their case by taking pot shots at our traffic expert. And that was a complete failure. The judge did not buy it. He said, that she was competent. She had a thorough analysis. She made conservative assumptions. And she concluded, and he accepted her conclusion, that there would be more than double the number of parking spaces needed. And the only evidence on the plaintiff's side was what the land court called entirely speculative testimony from Mr. Santon based on unfounded assumptions. So given the clearly erroneous standard, I don't think it's possible for this court to reverse the land court on the issue in front of us today.
Can I ask a question just to help me understand the standard here? So they're a butter, they had a presumption of standing, you presumably rebutted that presumption, and so there's a trial, and they have the burden then to show a reasonable likelihood that they'll be harmed, qualitative, quantitative. I'm not quite sure how those work out, but suppose they had shown, suppose they actually had proved that once a year, Landry and Arcari holds a wedding they get out their beautiful rugs and they have a big wedding, and on the once a year, there's going to be overflow of parking. Would that be sufficient for standing?
It wouldn't, Your Honor. Standing requires not just impact, but harm. And in this case, with a commercial property, it means harm to the business. So I would suggest that, a few cars overflowing into the parking lot at 133 Brimble, which is a large parking lot, very rarely full itself, In the worst-case scenario, if the parking lot were filled and there were a few vehicles there that were attributable to 143 Brimble, and somebody complained, and as Mr. Stanton testified, well, when that happened with the post, I complained and they fixed it. That still doesn't show harm to the business. Now,
You're arguing that as a matter of law or as a matter of fact?
As a matter of fact, Your Honor.
Assume for the sake of argument that the judge here not only credited Mr. Stanton's testimony, but said, yeah, I find that sufficient.
Well, I think he would have been in error had he done that, given the rigorous test under the Butler case that, you can't just come in and tell anecdotes. You have to show specific facts that prove that there's a likelihood of harm in the future.
So what if Mr. Stanton said at least 12 times a year, that entity, which was a smaller building with fewer people in it on a daily basis, at least 12 times a year under those circumstances, there was overflow parking that came into my lot and it hurt our business, and here's how. And the judge accepted that. You lose under that circumstance?
I think that would be in the ballpark, but it's that last part that would be critical, which is there were no parking spaces, my tenant complained, they asked for a rent abatement, it's happened several times, I'm going to not renew my lease because of the parking problems here, but that's a different world than we had at trial.
Just a factual clarification, my understanding is that at the time of the trial, at least, your clients did not own the property. Their P&S was contingent on some kind of zoning relief from the planning board. Do your clients own the property now?
They do. There are no other questions. I'll yield to my colleague.
We'll hear from the city.
Good morning, Your Honors. May it please the Court, Beth Oldmixon for the City of Beverly. In assessing the plaintiff's claim of standing, the focus must be on whether the harm will flow from the board's decision, not the merits of decision. Justice Milkey, you seemed to touch upon this earlier with my colleague. The plaintiff must present credible evidence substantiating his claim of aggrievement, here the loss of parking at 133. The plaintiff's evidence is flawed on multiple fronts. First, plaintiff's alleged harm, loss of parking on 133, cannot flow from a board decision granting relief in the form of allowing 25 spaces within the setback, which only bears on the location of those spaces. There is no evidence that cars cannot get into or out of all 74 of those spaces. It's not plausible or logical to suggest that the spaces located within the setbacks will result in cars seeking to park on 133 Brimble. Second, plaintiff's testimony regarding the parking needs of the post, which operated a large function hall, is not probative to the parking needs of the approved use, a high-end drugstore. In fact, the plaintiff offered no evidence of the defendant's parking needs other than pointing to the 72 spaces required by the ordinance, which the defendant exceeds. Third, it is not plausible that the cars will migrate from 143 to 133 because the evidence shows the plaintiff has created a physical barrier by installing the Jersey barriers.
No, but they can drive around.
They can drive around, yes, but as you pointed out, that does require some maneuvering. It's not as easy as it once was, and in fact, most patrons probably didn't even realize there was a lot line between the two at one point.
Where else would overflow parking go? Are there any garages around or anything of that nature?
There's no public parking around.
Is there any street parking right there?
There is no street parking.
So where else would overflow parking go?
The position is that there will be no overflow parking because there's plenty of spaces.
Time is short.
Sure.
And we didn't get the opportunity to ask Mr. Pinto about the mootness argument that you have joined in. I'm having a hard time understanding that argument, which would seem to depend on a presumption that the two owners of the other property are differently situated in some material respect. I don't think there's anything in front of us that suggests that. So how would this case be moot? Why can't the new owner just be substituted?
Sure. So, Your Honor, with respect to the mootness, jurisdiction does not attach until standing has been established. And here, standing has not been established, so jurisdiction hasn't attached in delayed court at this point. In addition,
No, but let's say their standing argument was meritorious. Somebody can't make the argument?
I think that would be a different analysis if the land court had found that there was standing and this was on appeal before you with respect to the merits. The question here is that there hasn't been an establishment of standing yet, and it was Mr. Stanton who testified regarding his anecdotal evidence with respect to the parking. It wasn't the new owners and their observations.
He's in that capacity a witness, isn't he? He's not. How does that turn on his party status?
I think it doesn't turn on his party status, it turns on the new party status. And as you pointed out, there could be ways to mitigate any concerns if the new party wanted to do that. And we just don't have the facts before us to.
No, but you're the one who's saying that it's moot. I mean, and I can envision situations where it may well be moot. Let's say they decided to turn that property into a public parking lot. That's the new use. They're very differently situated with respect to the standing argument in that event. We have nothing that suggests that they're not going to use this parcel for something similar to what the current use of it is. As complicated as that might be.
I don't disagree. I think the concern here is the timing as far as we haven't established standing yet and we're before this court. And we just don't have, as you pointed out, any knowledge of what that use will be with the new owners.
I see no further questions from my colleagues and seeing the red light on.
Thank you, Your Honor.
Thank you all very much. The case is submitted.
Thank you, Your Honor.
We are going to hear one more case before the mid-morning break. I say that for those of you who are on the fifth case. The mid-morning break will be approximately 15 minutes. The next case is 2023 P495, William Howard versus the Trial Court of Massachusetts. Counsel.
Good afternoon, Your Honor. Samuel Kennedy Smith for the appellant plaintiff, William Howard. I apologize in advance for my voice. My children besieged me with various illnesses prior to Christmas. This is an action that was brought under Chapter 30, Section 58, essentially the assault-based statute. William Howard is a 30-plus year, or was a 30-plus year officer of the trial court. He suffered numerous injuries in those 30 years, which are specifically pled in paragraph 7 of the complaint, which would fall within the circumstances of the assault-based statute. The complaint properly pleads that those injuries led to a period of disability following a final injury in June 2020. Excuse me. We specifically plead in the complaint in paragraph 10 that the trial court's expert in the context of the ongoing workers' comp proceedings, which is Dr. Louis Blay.
Can I cut to the chase on some of this? Let's assume that the past injuries that are specified in paragraph 7 of the complaint, all that past stuff, was not, it didn't exist. It never happened. So this again, pure assumption. So this case would depend on the more recent injury for which your client was out and receiving workers' compensation. Is it your position that that injury would qualify under the statute, or is it your position that the injury here was the even if that wouldn't qualify, in reality, the injury here was the exacerbation of this condition that was caused by all these other incidents that did qualify.
2 points, Your Honor. The June 2020 injury, which again was not pled because of the Commonwealth's expert, I don't believe that that necessarily happened under circumstances that would invoke Chapter 30, Section 58. And we don't plead or allege that it did. The really dispositive issue here is that he's sent to an IME in the context of the Workers' Compensation Court. And in that context, he's having a surgery to, I think, both thumbs. I think he had one and then another related to CMC arthritis and repetitive hand traumas, which again, Dr. Bly has provided these prior incidents. And that expert specifically opines that his then disability, his then need for surgery, and then need for treatment is caused by these qualifying incidents which previously occurred. And I would submit that the trial judge understood that, which is why she, again, I don't think that's much in dispute based on Flaherty and my brother's footnote 3. The trial judge started the statute of limitations from that July 2018 incident, which was the last incident of a qualifying assault pay incident.
I know you don't reference it in your complaint, or I believe you don't, but what exactly is a Form 110?
A Form 110, Your Honor, essentially workers' comp practice is heavily form-based. A Form 110 initiates an employee claim. A Form 104 or 103 is a denial or an acceptance of an injury. A 108 is a cessation. It's sort of used as the parlance of a complaint.
And so the Form 110 here lists the date of injury as 6/5/2020. It lists the first day of total or partial incapacity to earn wages as 6/5/2020. Describes the injury or exposure as tripped on the stair threads. So for you to succeed on your claim, it seems to me you're going to have to show, assuming you're successful on appeal, that, and I'm probably using the incorrect nomenclature, but that the causative event was all of these prior injuries, not the 6/5/20 injury. Is that correct?
I'm not sure it has to be the gradient of proof in terms of medical causation. Again, in the parlance of a workers' compensation case, it's slightly different, and that's part of the reason that Dr. Bly uses the major cause parlance, because that is something that a comp court would consider. But again, Dr. Bly is identifying essentially a cumulative repetitive injury caused by the violent acts of prisoners, and that leads to the disability. At that point, if the June 2020 incident, whatever happened in that incident, combined with that in some fashion, that becomes an issue of a medical proof that would be one more disposed to summary judgment, which is what I argued quite vociferously in the trial court. And again, that wouldn't be properly disposed of on a motion to dismiss.
I'm sorry if I just may. If there are there any cases which deal with this issue? And by deal with this issue, I mean where a court officer alleges that he or she has been hurt within the meaning of the statute or injured within the meaning of the statute years ago, and the cumulative effects occurred 5 years later such that they were entitled to these benefits.
The only thing I've seen, Your Honor, is in 2022, and I reference this in my brief about the Wage Act count, in the Howell decision of this court, which I believe is 101 Mass App Court 542, I believe there was an argument made at trial or appeal by the Commonwealth that, or excuse me, the Essex County Sheriff, that Officer Howell had not raised his entitlement to assault pay while he was employed, and that was some sort of waiver. That's all I've seen. Most of the published decisions deal with the attenuation between a violent act and the injury. So I think Officer Howell in that aforementioned decision was running to get some sort of riot blinds and falls down the stairs. And that's been the focus of the cases, is what attenuation is acceptable between somebody's being held hostage a couple rooms over and I fall down the stairs while responding. Does that fall within the assault pay?
So if the workers' comp cases use what you refer to as the major cause analysis, what would be the test? Say you prevail in this appeal, you survive summary judgment, and it's at trial. What is the test you need to meet as to whether this was caused by the old covered incidents or the more recent, likely uncovered.
Again, I'm not positive what it would be. It would be a battle of the experts, essentially, although they're...
That's the factual question in terms of what the legal standard would be.
Again, I'm not sure there is one, but again, I'm not sure that's dispositive as to the basis of my appeal.
There better be
one. We're setting the standard for a hypothetical expert that's a battle of factual dispute as to medical causation. I haven't even been allowed to get to that stage, Your Honor.
No, I understand that. This is probably an unfair question, but...
I could say the standard most favorable to my clients, but again, I don't think that that's an especially exotic issue here. That's a standard personal injury issue. Was this caused by the years of back arthritis or this slip and fall in snow and ice? And we bring in experts and we have it out.
Except it is a statutory question here, not a common law one.
Again, I think that to that point, what I would point you to is, especially from the Howell case, and I think even the Modica case and some of the cases cited by my brother, this is a broad remedial statute. The the legislature signaled out a specific class of individuals, correctional officers, and I think it's in the related statute under 18A, and then court officers, and said, due to the inherent nature of your job and the danger, we're going to make you whole if you are put on a workers' comp injury and you're receiving indemnity benefits due to the violent acts of prisoners or persons in the courtroom. And in the Howell case especially, the court read that incredibly broadly as a remedial broad statute for an important public policy purpose, which I would say would favor this sort of causation analysis were we to hypothetically end up back here on a medical dispute. I think the bottom line, Your Honor, from my point of view is the statute of limitations analysis was incorrect. Flaherty, that's a decided case. And to try to construct and say there's some sort of pleading error that we didn't plead a causal relationship between these prior accidents and the subsequent disability, we quote their expert in paragraph 10 of the complaint and make that connection explicit. So I don't understand how count one is the decision on count one.
Can we go ahead.
He said the expert says that his current condition and need for treatment is most likely the result of his 34 years as court officer and repeated trauma and the need for surgery.
And yes,
I guess the question becomes is whether that creates the nexus to, as a result of those injuries, he is then entitled to workman's comp. There is a difference between the two.
I'm not sure I understand the question, Your Honor.
Well, it's more of a statement than a question.
I didn't mean...
But
Trying to figure out what the standard was.
yeah.
So if he suffers a work injury without relation to cause, so the falling down a tread with the stairs, that's a compensable work injury. And if you look at, we supplied it as Exhibit C of our briefing. It was submitted to the trial court in that briefing, and it was submitted to Dr. Bly, the incident reports that document and substantiate paragraph 7. There were workers' compensation benefits collected individually for those incidents. There were periods of disability. And when I say workers' compensation benefits, you have wage replacement indemnification benefits, and you have medical benefits. There's no dispute that those were compensable work injuries, and they are pled thusly. It was an injury at the hands of a violent act that falls within the assault pay. So he suffers a compensable work injury, and it is eventually disabling. He should be entitled, and that if that compensable work injury was under circumstances that invoke Chapter 30, Section 58, he's entitled to assault pay, full stop, from my point of view. And again, I want to be crystal clear on this. Dr. Bly was provided the exhibits in Exhibit C. So what he is explicitly referencing...
Can I ask you, the exhibits, were the exhibits in Exhibit C part of your complaint? Or are these also materials like the Form 110 that are beyond the complaint?
We did not attach them to the complaint, but
okay.
Essentially from...
So we really can't consider them, can we? On a motion to dismiss
standard, I don't have the case site right at hand, but I believe if something is specifically cited in the complaint, that can be incorporated in the motion to dismiss standard. Those exhibits, which were presented to the trial court, the presiding judge, not to confuse this, and were attached as Exhibit C here, are the same exhibits that are explicitly referenced in paragraph 7 of the complaint. So the incidents of 1 through 10 in the subsections of paragraph 7 are provided to you as Exhibit C, just as they are provided to Dr. Bly.
In any event, they're pled in paragraphs.
Yeah, and again, but I think I think, again, there's a clear reversible error on the statute of limitations analysis. The question is whether you let the trial court or the Commonwealth pull that out by arguing essentially a dispute of medical experts.
No, the question is really whether you have pled within the meaning of Chapter 30, Section 58, that as a result of those prior injuries, your client is entitled to benefits under the Workman's Comp statute. You pled it a little bit differently. The question is whether it's a reasonable inference from the way you pled it. You said as a result of these injuries, or the doctor concluded that his condition is because of these injuries. And as a result, in paragraph 11, he was on medical leave while collecting workman's comp benefits. That's different than what the statute says. The question is whether what you have pled constitutes a reasonable inference.
I understand respectfully, Your Honor, paragraph 7 pleads multiple work-related incidents at the hands of a violent prisoner. So there are qualifying incidents. We plead a causal relation between those work incidents and a subsequent period of disability. We plead in paragraph 10 that, quote, those prior, and this is quoting Dr. Bly, those prior work injuries are a major cause for the need for treatment, including surgery. And then we say, as a result of his work injuries, plaintiff was on medical leave while collecting workers' compensation. So we've pled that it was a compensable injury under Chapter 152. We've pled that it was caused by violent incidents.
You're saying it's therefore a reasonable inference, if not a necessary inference, that therefore he is entitled to continuing workman's compensation benefits going forward.
Yes, in fact, we plead, I think, in the following paragraphs, from June 5th, 2020 up to and including the plaintiff has received weekly workers' compensation benefits pursuant to GL 152, but has not received penny payment under GL 3058. And we actually plead that our expectation is that, I think he's forcibly disability retired after 2 years of comp benefits, that it's our expectation that he will continue to collect those in the future. So again, had I pled simply, well, he suffered a fall on stairs, and
you were careful not to do that, I understand.
Honestly, Your Honor, I didn't handle the comp case, so I knew that I had a medical opinion that said that these prior work violent injuries are what caused his disability, and I pled it that way. There wasn't obfuscation here.
Can I just ask, the basis of your Wage Act claim is non-payment of the assault pay?
Yes, and I realize I have a bit of an uphill battle as I run out of time, if I can briefly
You can certainly respond.
Yeah, under Donahue, but I would again direct the court to Howell, and that was decided as...
But Howell's not a Wage Act case, though.
It is. It's an affirmation of a Wage Act award predicated upon the failure to pay assault pay.
Yeah, but Donahue, you say Donahue doesn't apply because that was an overtime case and this is an assault pay case. The theory of Donahue is that under the relevant terms of the statute, a court officer is not a worker, et cetera, whatever the phrase is, and neither is a court a penal institution. And that's the reasoning of Donahue. Doesn't that reasoning apply here just as easily as in Donahue? That is, Donahue didn't turn on whether it was overtime and not assault pay.
Again, what I would point out, Your Honor, is that below the argument was that the Chapter 30, below in our case with the presiding judge, it's very awkward when your defendant's the trial court, I apologize. The presiding judge, the argument was essentially that Chapter 50, Section 58 did not have that it was unenforceable, that we had a harm without a remedy. And what I pointed to was, say, a series of cases, I think it's the Ludlow case that's in that briefing, that says that naturally segues to the Wage Act. That was my argument then. Subsequent to that briefing, Howell came out, talked intensely about the broad remedial nature of of the Assault Pay Act, and affirmed a judgment that set a failure to pay assault pay, again, under the correction officer version of the statute, which is virtually identical to the trial court officer, but it affirmed a judgment of a...
Just one last question from me. Are you saying that Howell and Donahue are inconsistent?
Not necessarily. I think there's different considerations given the broad remedial nature of the assault pay statute that's expressly set forth by the legislature. Thank you, Your Honors.
Thank you very much. We will hear from the trial court.
Good morning, Your Honors, and may it please the Court, Assistant Attorney General Joe Lucia on behalf of Defendant Appellee, the Trial Court of Massachusetts. The Superior Court's dismissal of Plaintiff William Howard's two-count complaint should be affirmed by this Court. Mr. Howard's Wage Act claim against the trial court was properly dismissed on the ground of sovereign immunity, and Mr. Howard's assault pay statute claim was also properly subject to dismissal for failure to state a claim upon which relief can be granted.
Before we turn to the pleading issues, can you just address sovereign immunity quickly? You've heard the argument that Howell supports, at least appears to presume, a waiver of sovereign immunity. How do you respond to that?
So the Howell case, in my understanding, was an assault pay statute case. It was not a Wage Act case specifically. It was a case under the assault pay statute, and the Howell case concerned the definition of resulting from inmate violence, as that phrase is understood and used in the assault pay statute. The court in that case held that a corrections officer need not be in the presence of a violent inmate or be the specific target of an inmate's violent act to suffer an injury resulting from that act. Here, the trial court is not arguing that Mr. Howard failed to allege an injury resulting from an act of inmate violence, but rather that he has failed to allege that such an act is what entitled him to workers' compensation benefits as of June 5th, 2020. For that reason, I would argue that...
Can I just note before you go that has nothing to do with the Wage Act, right? The Howell case has, to Justice Milky's question, it's not a Wage Act case at all.
That's my understanding.
So it's not inconsistent with Donahue at all.
Correct. Donahue is the prevailing case on the Wage Act, and it's the case that dooms plaintiff's claim under the Wage Act here.
Okay, why don't we turn to the 12b-6 on the count one?
On count one, the assault pay statute. So in that count of the complaint, Your Honors, Mr. Howard asserts that the trial court violated the assault pay statute by failing to have paid him the difference between his weekly workers' compensation benefits received as of June 5th, 2020, and his regular salary. The assault pay statute provides, in relevant part, that a court officer who receives bodily injuries resulting from acts of violence...
We've read all this. We know this. The question is, was a claim sufficiently asserted in the complaint? I'm looking at the complaint on my screen. He alleges in paragraph 7, alleges 10 incidents
involving violent prisoners.
Yeah, involving violent prisoners that, at least for pleading purposes, would appear to establish that they'd be covered by the assault pay statute. Goes on to allege causation to the point of citing the independent medical examiner's opinion that, without distinguishing between the incidents in paragraph 7 and the incident in the form 110, whatever it is, says, I believe that the current condition and need for treatment is most likely a result of his 34 years as a court officer and repeated trauma and sprains. I understand that there may be a dispute as to medical causation that warrants exploration as summary judgment or trial, but for 12b-6 purposes, hasn't he alleged enough to get by?
No. And the reason for that, Your Honor, is because the requirements under the assault pay statute are that the plaintiff plead an explanation or why it was that he was entitled to workers' compensation benefits as of the date that he alleges he was so entitled. Here, June 5th, 2020 is the date. That is the date that he receives workers' compensation benefits. Now we need to know why. Why did he receive workers' compensation?
The IMEs explained why.
Certainly did not, Your Honor. I would argue that the IME, first of all, the IME's report is dated a full year after the workers' compensation benefits began. The independent medical examiner's report is dated May of 2021, which is nearly a whole year after the workers' compensation benefits began. Furthermore, the document, the IME's report does not, it fails to fill the allegation gap concerning why Mr. Howard was entitled to workers' compensation benefits. The evaluation does state that Mr. Howard had injuries to his thumbs, and it opines that based on the incident reports that Mr. Howard had provided, the current condition, again, as of May of 2021, that current condition and his need for treatment is most likely a result of his 34 years of being a court officer and repeated trauma and sprains to the base of both thumbs. These prior work injuries are a major cause of the need for his current need in May of 2021 for treatment and for surgery. This May 2021 document does not comment at all about why Mr. Howard began receiving workers' compensation benefits as of June 5th of 2020. That is the major question. The opinion doesn't even mention workers' compensation. And for purposes of the assault pay statute,
Wait,
matters.
sorry, time out. The opinion, the IME's opinion doesn't mention?
Does not reference workers' compensation benefits.
Isn't that the whole point of the IME?
There's nothing expressed in the IME's opinion, as there can't be, as to why he received workers' compensation benefits as of June 5th, 2020. What we know is that there was an incident on June 5th of 2020. My brother has conceded that there was an injury that occurred, an injurious event on June 5th of 2020, and that's when his workers' compensation benefits began.
Isn't it quite plausible that that incident on the stairs exacerbated a condition caused by his, to quote, 34 years as a court officer?
Certainly. It's possible that his June 5th, 2020 injury exacerbated prior existing conditions or prior injuries that he had sustained. The question for the assault pay statute, however, we would argue, is what is the event that caused the injury as of that date, entitling the plaintiff to workers' compensation benefits?
How does that jibe with the language of the statute that says an employee who is injured by a prisoner who, as a result of such injury, would be entitled to workers' comp? It doesn't say received workers' comp. It said would be entitled to workers' comp.
That is a wrinkle in the statutory language that is a bit confusing, Your Honor. I would agree with you. However, the next statement, I believe, the next sentence of the statute provides that the workers' compensation benefit then is being used to calculate the assault pay benefit. In other words, you can't have an assault pay benefit in the absence of payment of workers' compensation. So while the language of the statute does suggest sort of a theoretical entitlement to workers' compensation, the practical import of the statute requires that workers' compensation actually be paid, because to simply have a theoretical entitlement to workers' compensation would not allow you to calculate the actual amount of your assault pay benefit. So in our reading of the statute, the requirements for pleading a claim under 12b6 to withstand and defeat a 12b6 motion, the plaintiff must have pled that he received a bodily injury as the result of inmate violence or prisoner violence in a courthouse setting, that which event and injury therefore entitled him to receive workers' compensation benefits.
So let me ask it this way. Take a look at paragraph 11 of the complaint. Sure. It says, as a result of his work injuries, plaintiff was on medical leave while collecting workers' comp benefits from 6/5/20 up to and including the present. What if added to that was a sentence that read, and as a result of these specified work injuries, plaintiff is entitled to benefits under said chapter 152. Would that be sufficient?
That would be better. That would certainly be better, and I think it would be sufficient if the court or the judge were able to plausibly agree that injuries occurring over the course of a 2-decade span at the earliest, or at the latest, I should say, 2 years prior, is what truly triggered the entitlement to workers' compensation as of June 5th, 2020.
Isn't that a factual
inference? Isn't what I just said, though, a reasonable inference taking the plea as a whole?
I would agree. And that language would be sufficient, I think, because it is a reasonable inference for sure. Here, however, what we have is language that does not expressly allege why Mr. Howard began accepting or receiving benefits as of June 5th, 2020. We just know from the pleading itself that he suffered a series of incidents over the course of a 2-decade span, and somehow, almost 2 full years later, he begins collecting workers' compensation benefits there's no direct allegation that those benefits were an entitlement he had because of a violent inmate incident that caused him injury, and that's what makes the pleading insufficient for purposes of defeating a 12b6 motion. That is the missing allegation. And of course, as the court knows, if you consider the Form 110 that has been attached to the motion to dismiss, it becomes clearer the actual injury-causing event was falling down the stairs, tripping.
Was the Form 110 actually appended to the complaint?
It was not. Okay. It was attached to the motion to dismiss, and it was...
By the Commonwealth.
By the Commonwealth, that's correct. And we would argue the court may consider that document in considering whether or not to affirm the order of dismissal, because it was a document that the plaintiff clearly had notice of, is a document the plaintiff does not contest, and it is a document the plaintiff arguably relied on in framing his own complaint.
What if he tripped on the stairwell while chasing a prisoner who had...
Yeah, then he's entitled. Then
that would be completely irrelevant for workers' comp purposes, right? Aren't you reading a lot into that very short sentence on the Form 110?
I'm reading the Form 110 sentence as it's written, yes, and I am presuming that that's all the information we have on the Form 110, Your Honor, but you're right. If there was more factual development and it comes to light that he tripped on the stairs because an inmate pushed him, that would be a very different scenario, and that's possible. It's arguably possible that those are the facts. What we see here is that he tripped on the stair thread, and based on those words alone, I don't think that's sufficient to infer that it was on the basis of inmate violence.
You are asking the judge, and us for that matter, to consider material that is outside the complaint, not referenced by the complaint. Why doesn't that turn this into summary judgment?
Yeah, for that proposition, Your Honor, I would rely on the Merrim case. So obviously, in his complaint, Mr. Howard alleges that he began receiving workers' compensation benefits on June 5th of 2020, and this is, of course, the form that he submitted to request those benefits. Even if that document is not specifically referenced in the complaint, it is still a document of which Mr. Howard had notice and upon which he relied in framing his complaint, and therefore it may be considered by the court in assessing the sufficiency.
Why did he rely on that document in framing the complaint?
Well, just simply insofar as the document is evidentiary support of the allegation that he began receiving workers' comp as of the date. The Merrim case is instructive here, Your Honor, and I would encourage you to consider it. In the Merrim case, the defendants attached a private offering memorandum and subscription agreement to their motion to dismiss, and the SJC determined that as a result, those documents were quote-unquote included in the record. The SJC also noted that they were not contested by the plaintiff, and the SJC stated that the plaintiff had notice of those documents and relied on them in framing the complaint, even though they weren't themselves attached to the complaint, and they could be considered on a motion to dismiss. I will concede, Your Honor, this case is not exactly the Merrim case, and I agree with you that it is not a clear-cut conclusion that he relied on this document in framing his complaint.
And am I correct in assuming that when the SJC issued Ayachinko, or however you pronounce that, and changed the 12b6 standard, it didn't change the doctrine that we read all factual allegations to be true, and it didn't change the principle that we are to give the plaintiff the benefit of reasonable inferences?
You're correct. Those are still the standards that apply when assessing the sufficiency of a complaint and assessing or analyzing the strength of a motion to dismiss. What Ayachinko did, however, was establish that allegations must plausibly suggest an entitlement to relief, not merely be consistent with it. And I ask this court to consider whether the allegations as pled here are in fact plausibly suggestive of an entitlement to relief as opposed to merely consistent with that entitlement.
I have a question, might be unfair, but I'm going to ask it anyway. In the motion to dismiss, which you did not file, it was filed by a colleague, there was an argument that the assault pay statute doesn't create a private cause of action. You did not advance that in your brief anymore. Have you abandoned that argument or merely waived it?
We are not advancing that argument here on appeal, so for that, I would understand that that's probably waived.
Good, thank you.
You're welcome.
Thank you both very much. The case is submitted. We will now take a 15-minute break. We will be back on the bench by 12:15.